Imagine you have received disappointing news, an immigration benefit or visa denial. It can feel like the end of the road, leaving you wondering where to turn next for help. The key to knowing whether to appeal to USCIS or a consular office depends on who made the original decision and what kind of decision it was. Generally, you appeal to USCIS when an immigration petition filed within the United States is denied. You appeal or seek reconsideration from a consular office when a visa application abroad is denied. This distinction comes down to the different roles each agency plays in the immigration process. USCIS, which stands for United States Citizenship and Immigration Services, handles applications and petitions for immigration benefits inside the United States, such as I-130 petitions for relatives or adjustment of status applications. They decide if you meet the eligibility criteria for a benefit. Consular officers, on the other hand, are part of the Department of State and work at U.S. embassies and consulates abroad. Their primary role is to determine if an applicant is eligible for a visa to enter the United States after a USCIS petition has been approved, focusing on things like admissibility and fraud prevention. So, if USCIS denied your relative's petition, you appeal to them. If the consular officer denied the actual visa at the interview, that is where you address the issue. To figure out your next steps, first, carefully read the denial letter you received. This letter is crucial because it will explicitly state the issuing agency and the reasons for denial. If the letter is from USCIS and concerns a petition like an I-130 or I-485, you might file a Form I-290B, Notice of Appeal or Motion, to the Administrative Appeals Office, or a AO. This must usually be done within 30 days. If the denial was from a consular officer at an embassy or consulate, you generally do not file a formal appeal form. Instead, you usually address the specific reason for the denial by submitting additional evidence or requesting a reconsideration directly with that consular post. Understanding the specific type of denial, whether it is one of eligibility versus one of admissibility, is critical for determining the correct path forward. An eligibility denial by USCIS means you did not meet the requirements for the benefit you applied for. An admissibility denial by a consular officer means you are prohibited from entering the United States for reasons like certain health conditions, criminal history, or misrepresentation. These are distinct legal concepts with different resolution processes. Knowing this can help you gather the right documents and present your case more effectively. Navigating a visa or benefit denial can be challenging, but understanding the difference between USCIS and consular jurisdiction empowers you to take the correct next steps. Whether it is filing a formal appeal with USCIS or addressing the specific concerns of a consular officer, precise action based on the denial letter is key to keeping your immigration journey moving forward. Remember, acting promptly and seeking legal guidance can significantly improve your chances of a positive outcome.